So damages may be classified as performance damages or non-performance damages. Non-performance damages, we refer to them as monetary damages, money damages. Now there are three components of monetary damages. The first being compensatory damages, the second being incidental damages, and the third being consequential damages. And our recovery for monetary damages is going to be the sum of compensatory plus incidental plus consequential. So these three components added together form monetary damages. Let's talk about each one in more detail. Compensatory damages compensate the non-breaching party for the loss of the benefit of the bargain, meaning for the loss that the non-breaching party suffered. So if a seller, for instance, fails to deliver goods or delivers non-conforming goods, and the buyer has been able to purchase substitute goods, the buyer is going to be able to claim damages if the substitute goods cost more than the contract price. A seller can claim damages if the resale price is less than the contract price. So compensatory damages are meant to compensate the parties for the loss of the benefit of the bargain, and ordinarily compensatory damages are made up of the difference between contract price and market price. Now the second type of monetary damage, or second component of monetary damages, are called incidental damages. And these are damages that are directly caused by the breach. Incidental damages are those expenses that a party suffered as a result of the breach. And for our purposes in here, when you think of incidental damages, we're really looking at the cost of mitigation. How much did it cost to mitigate damages? Because if we have an agreement and you're going to sell me your computer for $750 next Tuesday, and next Tuesday arrives, and I show up and I say, here's my $750, and you say, I'm not going to sell you the computer. Now, what I'm going to do, I, as a buyer, have an obligation to go purchase substitute goods. So maybe I go into the market and I find a substitute good, a substitute computer for $1,000. Well, my compensatory damages are going to be the difference between the contract price and the market price, $250. But we have to understand this, we have to take into account the extra cost suffered as a result of the breach. If I can establish that it cost me $50 to find a substitute good, then in order to make me whole, I must get the $250 difference between what I paid and what I expected to pay, but I must also receive the $50 that I paid that I would not have had to pay but for the breach, as a direct result of the breach. So it's generally the cost of mitigation. If a buyer breaches and fails to take delivery of the goods, the seller has an obligation to go resell those goods, and that seller is going to be entitled to receive the difference between the contract price and the market price. So same example, I show up and I say, I am not going to pay you the $750 for your computer. You go out on the market, you resell it for $650. The compensatory damages, you have a right to sue me for $100. That's the difference between what you expected to receive, $750, versus what you actually received, $650. So $100. But if you can show that it cost you $100 to resell the good, then you're entitled to that money back as well. So in this case, you would get the $100 of compensatory damages plus the $100 of incidental damages. Now, attorney's fees are a special type of incidental damage, meaning if I have to go to court and sue you, I'm going to have to go hire a lawyer, and that lawyer is going to cost me money. Now, unfortunately, well, the parties can always agree to themselves whether attorney's fees are recoverable or not. If there is no provision in the contract for recovery of attorney's fees, in the United States, we follow a rule that says recovery of attorney's fees is not an element of damages. They are incidental damages, but we are going to ignore that because in the United States, we treat attorney's fees simply as a frictionless method of obtaining your compensation. So recovery of attorney's fees can depend on which law applies, and here we're really talking about the United States versus the rest of the world. In the rest of the world, for the most part, attorney's fees are a form of incidental damage. They are amount of money that I would not have had to spend but for your breach, and I, as the non-breaching party, have a right to recover those. The third component of monetary damages is called consequential damages. And consequential damages are the damages that flow from a breach. They occur as a reasonably foreseeable consequence of the breach. And for our purposes, thinking about consequential damages, primarily we'll see it in loss of profit. So if you are a buyer and the seller breaches, you have lost out on the ability to resell those goods out into the marketplace. And you have suffered a loss of profit. That loss of profit is a consequential damage, meaning you, the buyer, are now able to recover the compensatory damage, the difference between the contract price and the market price. And if you're a buyer, then the market price is going to be higher than the contract price. You're going to be entitled to incidental damages, which are the cost of going out to find a substitute good. And you're going to be entitled to consequential damages, which arose as a result of the breach. They weren't caused by the breach, but they were there as a result of the breach. So you were unable to sell the goods. Now, consequential damages is a very contentious part of the law. And what we will often see in contracts is simply a waiver of the right to consequential damages. Because a contract always controls, the parties can agree between themselves that consequential damages are not obtainable. And parties will do that often because consequential damages can grow exponentially. You didn't sell the goods at the time you were going to sell them. You suffered a loss of profit. That loss of profit caused you to have to close your business. That's going to cause all sorts of other damages. Now you're going to be, now you owe money to your landlord that you would not have owed but for the original breach. So consequential damages can flow down the chain and we have to cut it off somewhere. And for many parties, they cut it off by saying they're not recoverable. If you have signed any sort of contract or made any sort of agreement, you should know that you have probably waived any consequential damages. So for instance, in your cell phone agreement, undoubtedly in your cell phone agreement, there's going to be a provision that says if a party fails to perform, the other party cannot claim consequential damages. If I contract with T-Mobile to provide me service and the service goes out for a day and I miss a very important call offering me a job and they call someone else and offer them a job, I'm not going to be able to sue for the difference for those consequential damages. I can sue for the loss of the day's use that I didn't have service, but I can't sue for what occurred as a result of that. So any contract that you've signed, whether it's your Xbox agreement or iTunes agreement or cell phone agreement or credit card agreement, almost certainly you have waived consequential damages. One type of contract where you always see a waiver is for when you put your goods on an airplane. When you buy a ticket and you check your bag, and if the bag doesn't arrive, you're going to be entitled to a certain amount because of what you lost in the bag, but you cannot recover for consequences of what was lost in the bag. So consequential damages. So on your test, you want to check to see, first of all, in any contract problem that I've set out, have the parties waived consequential damages? If they have, then consequential damages are not recoverable, and instead we must look to only compensatory damages and incidental damages as the measure of our recovery.